Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book which is one of my favourites actually. It's from Jordan's and it's a new edition. It's called simply Judicial Review. There's the book there, spine, and there's a little bit on the back. It's a practical guide. The book itself is structured quite well. I do like the forms and precedents, which I think are extremely helpful for the novice. And what you do have, of course, are the standard very detailed footnotes, and you've got paragraph numbering at the sides. The book runs to something approaching just under 600 pages. There's a useful index at the back to find things. Again, as I say, when you hear the review I'm going to present, you'll realise why I think this is good for across-the-board people. It's the contents section there, and of course a huge amount of case law, which you can see. Do read the foreword, which I think you will also find very helpful, trying to understand how to go through this book. There are quite a lot of books on the market about judicial review, but I think this is one of the best ones. And I say that because it actually covers a wide range of matters which I think are directly relevant to those I certainly advise in judicial review proceedings. We've given it a title for everyone, from experienced practitioners to litigants in person, a step-by-step guide to judicial review, and that's what it is. It's written by Hugh, Southey, Queen's Counsel, Amanda Weston and Jude Bunting, and as I say, I think it's a very good book. What we've said, and we start off with someone I'm sure many of you will know, made a comment, Stephen Sedley, as a Lord Justice of Appeal. Stephen Sedley reminds us in the foreword to the second edition of the book that judicial review of governmental acts and omissions didn't even feature in the bar examinations in the 1960s. Now this is obviously in the second edition, but to someone of my vintage, judicial review was really taking off in the 70s and obviously changing the face of the way we view decisions by public organisations. The book itself, I think, is very up to date. Now, of course, judicial review is what we would describe as centre stage in both legal theory and legal practice, and this is not the only distinctive aspect, of course, of judicial review. Another is the central and salient fact that in judicial review, it's the state primarily that is one of the parties. Thus, the purpose of judicial review, at least in theory, is to hold open the option for individuals to challenge the might of the state, and of course at a cost. And I think that is the one area which has always worried me, and I always remind my clients of it. This book does show you how to go about judicial review, but you've always got to bear in mind what happens if you don't win. From the signing of Magna Carta in 1215, as the authors point out in the preface, the common law has developed, not without struggle, to protect fundamental rights and freedoms, and that is very important even today as we approach an anniversary of Magna Carta in 2015. So it's curious that it's only within the last half century or so that judicial review has been formally instituted to uphold these rights. Judicial review, of course, is intended to ensure that decisions made by the state that affect the lives of individuals or groups are both democratic and lawful, and the guide, therefore, gives you some indication of where we're going with it. We hope, say the authors, that both experienced lawyers and litigants in person will be able to rely on the book to guide them through the process, and I think they will. I would certainly advise anybody thinking of judicial review to look at this book very carefully. It's not an expensive book. It's certainly an important one. The book's divided into 4 parts, and the second edition cites a number of new developments both in law and practice, certainly on costs, in particular part 52 of the CPR. From students and academics to experienced and inexperienced practitioners alike, therefore, anyone interested in this complex but fascinating subject, or professionally involved in it, should rush out and get the book today, in our view, as a matter of priority. I'd like to thank Jordan's very much for the new edition and the authors, because they put a lot of work in, and it's a very useful book, as I say, for everybody. So thank you to all concerned. Bye-bye.